Good morning, everyone. Bonjour tout le monde. Green Party leader Annamie Paul's roundtable discussion with the Association of Iroquois and Allied Indians on Bill C-15 with special guests Grand Chief Joel Abram, Deputy Grand Chief Stacia Loft, and Sara Mainville and Chief Carr will now begin with an opening prayer from Elder Harvey Bell. La table ronde d'Annamie Paul, chef du Parti vert, avec l'Association des Iroquois et des Indiens alliés sur le projet de la loi C-15, avec des invités spéciaux, le Grand Chief Joel Abram, le Grand Chef adjoint Stacia Loft, Sara Mainville et Chef Carr, commencera maintenant avec une prière d'ouverture de l'aîné Harvey Bell. Merci.
Ali, bonjour. We give thanks to Getty Manado for today to be together on behalf of our citizens, our communities, our people. We ask for guidance and wisdom, and we ask for protection for all of our citizens, all of our communities, all of the people that we work with, and for all of your families, your friends. We ask for protection from this COVID pandemic, which is still with us, and we ask for it to keep everyone safe.
Thank you very, very much. And we're going to go now to Grand Chief Joel Abram for opening remarks.
All right, thank you very much. And I guess I'd like to begin first of all by thanking the Green Party and Annamie for, their support behind the AIAI, or the Association of Iroquois and Allied Indians, and we have concerns about Bill C-15. So again, we thank them for listening to us and being the only party that was really willing to listen to our concerns and help maybe carry forward some of our concerns to Parliament. And so let me just kind of go briefly over some of our concerns around Bill C-15, which is around implementation of the United Nations declarations on the rights of Indigenous peoples. And so although the cause of promoting UNDRIP is worthy, there are a lot of issues with it as well. And basically what it does, the way that it's written now, is it reinforces the status quo because the bill makes it clear that existing national laws, many of which violate Indigenous rights, will prevail over UNDRIP. In the main section, maintain a common law interpretation of section 35.1 and 35.2. And those are heavily based on a colonial doctrine of discovery, and that which strips of Indigenous people of their land ownership and land rights. And so the primacy of the doctrine of discovery means the courts will continue to adjudicate using existing case law based on section 35, and these rulings have caused major harm to daily life. And, the purpose of UNDRIP is to decolonize. So, what it does is it infers the imposition of crown sovereignty over Indigenous peoples, including self-government rights. It disregards Indigenous laws and traditions. It establishes that the Crown has ultimate title to the land, and the burden of proof is imposed on Indigenous peoples and nations to establish their rights in Canadian courts. For instance, the Sparrow test that allows for infringement of Aboriginal rights under all sorts of circumstances, and the erosion of the duty to consult and accommodation to nothing more than a procedural right that's reviewable based on an administrative law. So if it becomes law, all 46 articles of the Declaration will be interpreted and implemented through a colonial Canadian constitutional framework instead of respecting international law regarding the rights of Indigenous peoples. The federal government has their inherent self-government policy, and it doesn't follow the United Nations, Civil and Political Rights Convention, which says that all peoples have the rights to, self-government, basically. But the federal inherent right says the inherent right of self-government does not include a right of sovereignty in the international law sense, and implementation of self-government should only enhance the participation of Aboriginal peoples in the Canadian Federation as a fourth level of Indigenous government. And so, we feel strongly that UNDRIP will be used to justify in the removal of Indigenous rights to self-determination. And with that, all the other promised rights of UNDRIP, including restoration of stolen lands, territories, resources, or restitution for stolen lands, in the articles requiring free or prior informed consent for developments on lands of Indigenous peoples, though that would be meaningless. So in other words, by placing UNDRIP beneath existing Canadian law, they will domesticate our rights out of existence, and we won't get the true meaning of UNDRIP. Thank you.
Thank you very much, Grand Chief Abram. I am just going to make the very briefest of remarks before continuing along. I come to you from the traditional territories of the Mississauga of the Credit, the Anishinaabe, the Haudenosaunee, and the Huron-Wendat, otherwise known as Toronto. And it is a pleasure to be able to host this event today. As we consider Bill C-15, it is so very, very important to ensure that all First Nations, Inuit, and the Métis Nation get not just consulted, but are involved. And the importance of that cannot be overstated. And so when the Association of Iroquois and Allied Indians contacted us to share their views on Bill C-15, and also to say that they had not been consulted, that they had not been involved in the creation of Bill C-15, the simplest thing that I could think of to do was to offer the platform that we have as a party for them to share, for the association to share in an completely unfiltered way their point of view, with the hopes that it will be heard and that it will make a difference in terms of what happens next with Bill C-15. The Green Party has been really clear on this, that we do not consider these things to be a box checking exercise. We are committed to reconciliation, to nation relationships, and self-determination. And that means that it has to be true nation-to-nation conversations. And so that is the purpose today. I'm very grateful to the association, to AIAI, for being with us today and for sharing their view. And I'm going to leave it at that, as this is really intended to be for you. And so with that, I'm going to pass it now to Chief Carr for her remarks.
Ani bojo, wawash keshto dem, megase kwe dishnakas, Laurie Jaganashnozwin, Michisagi, Anishinaabe, and Dao. Hello, everyone. My name is Laurie. My Indigenous name is Eagle Woman. I am from the Deer Clan and chief of our community of Hiawatha First Nation. We're located on the north shore of Rice Lake here in Ontario. And just a few words. First, I would like to give thanks to the elder for opening us up in a good way, and for those who have those sacred items in front of you, miigwech for those. And thank you for the invitation to say a few opening words. I won't talk long. However, I just wanted to note, and as Grand Chief had mentioned in his opening words, when we're talking about legislating UNDRIP, Bill C-15, along with other negative impacts to our peoples, this will give state integrity, Article 46, meaning it'll give authority over the territory, meaning our territories and lands, to the state. None of our rights, none of our lands should ever be legislated by the states, such as our languages and children, which were legislated. And our languages and children do not belong to the state of Canada. They belong to us. They belong to our nations, to our people. And we as First Nations cannot allow the Canadian government to legislate UNDRIP. This was meant for Indigenous peoples, not for Canada to take advantage of against our peoples and lands. And it was in the UN Convention of the Elimination of All Forms of Racial Discrimination, CERD, asked Canada in March of 2012 to produce the documents that show they have the rights to our lands. To this date, these documents have never been produced. And that's because we did not give our lands away in the treaties. So when we allow, or when these pieces happen to our people, when legislation happens that isn't for our people, it takes from all of us, Indigenous and non-Indigenous, and it takes from our future generations. And it doesn't allow, it's that form of racism all over again. It doesn't allow us to grow as who we are and how we're supposed to be. And it doesn't allow us, it doesn't give us that life that Creator intended for us. Miigwech.
Thank you very much, Chief Carr. I'm going to pass it now to Sara Mainville. Sara, if you want to just introduce yourself and then make your remarks.
Thank you. I will introduce myself in a traditional way. Buju, Kabamashit, Pinisikwe, Indigenous Makwato, Dem, Kuchiching, and Doshi. I'm very happy to be here supporting my client, the Association of Iroquois and Allied Indians, who have made a strong stance, not just regarding this particular piece of legislation, but about the rights recognition framework that was announced in 2016 on Valentine's Day. And what these First Nation communities are doing is protecting their inherent sovereignty and their territories and the original intent of treaty making in Canada. And so I think that their perspective should be very much valued by all Canadians, and specifically around Bill C-15. And I want to go through some of the most important sort of high-level view of the bill itself. First of all, the bill does not accurately reflect the status of the declaration is binding international law. The bill also does not implement the declaration. The bill itself is called an act respecting the United Nations Declaration on the Rights of Indigenous Peoples. And Canada's commitments and implementation process are vague in the bill itself. And the important principles in the preamble are not reflected in the operative sections of the bill. The relationship between the declaration and Section 35 of the Constitution Act 1982 is left uncertain. And I think the uncertainty plays up to the same game that we've had to play since the last 36 or 37 years of Section 35, is going to court and having courts that are ill-equipped to understand treaty relationships, to interpret Indigenous people's rights from the perspective of a sovereign subject perspective, that Indigenous peoples are in fact Canadians, when in fact my clients see themselves as Indigenous peoples, Indigenous nations, and this should be reflected in this bill. So there are specific sections of the bill that I don't want to spend too much time on, but through our work with Association of Iroquois and Allied Indians, we have certainly shown how the bill reflects a weak or watered down version of not only the declaration, but also of Section 35 rights. And this is also reflected in some of the criticisms that AIAI has put up and passed on their social media and on their website about the 10 principles that this government has put in place in 2016 regarding their view of the common law, which is certainly a crown settler colonial viewpoint of Indigenous rights in Canada. And so I think one of the main threats is how the act is asking governments and the courts to see the declaration through the lens of the many colonial tests in Section 35 of the Constitution Act. And we can talk about that in more specific terms and understandings later in the presentation, but for certain, the bill is weak, and for certain, we believe that the weakness will exacerbate the denial of Indigenous rights in Canada, and for that reason, the Association of Iroquois and Allied Indians does not want the bill to become law. Miigwech.
Thank you very, very much for that. And now we pass to Deputy Grand Chief Stacia Loft.
Sego sewa gwego, niga hadaki youngets, and Bindege nitawagenon. Good morning, Sego everyone. Hello, my name is Stacia Loft. I am from Tyinanega Mohawk Territory and Deputy Grand Chief of the Association of Iroquois and Allied Indians. I'd like to extend thanks to Harvey for the opening prayer. It's important that we open up our time together with an open mind and an open heart, particularly around our discussion today on C-15. I'd also too like to thank Grand Chief Abram and Annamie, Chief Carr and Sara for their opening comments in order to frame the rest of our discussion this morning. I'd also too like to welcome those who have joined us today for our discussion, and glad that you're part of this with us. It's critical that any process that we engage in, that we start off in a good way, and most importantly, with a good mind, that ganaguio. And although many of us have been waiting patiently for the implementation of UNDRIP in Canada since it was adopted in 2007 by the UN General Assembly, it is necessary that the process is undertaken with trust, friendship, and respect. Many nations do not have an issue with UNDRIP, with international UNDRIP, but many take issue with Canada's version of UNDRIP. Canada's process of implementing UNDRIP has been flawed from the start. One issue is that Canada has not adequately or appropriately engaged with Indigenous peoples. Only 6 weeks were set aside for engagement purposes, and mostly with national Indigenous organizations and provinces, but with no invitation extended to rights holders or nations individually. Leadership in Ontario were only given 3 days to confirm their participation in the UNDRIP engagement process, and the sessions were capped. They were capped at 50 participants, which represents only half of First Nations in Ontario. AIAI reached out to Minister Lametti in the fall of 2020 to meet with the AIAI Chiefs Council, but we didn't receive a response. Later, a representative did state that the minister was not going to meet with the AIAI Chiefs Council and that the engagement period would not be extended past December of 2020. No nation-to-nation engagement process occurred. No meaningful, no thoughtful discussion, no opportunity to provide feedback from the nations or right holders that are directly to the government after or on the draft bill. None of that took place. The bill was tabled, and since the House resumed in January, the bill is now in its second reading. The engagement process was fatally flawed from the start. Nation-to-nation relationships do not work in this way. Canada's shortcomings on the engagement process are in conflict with the principles of free, prior, and informed consent, whereby all peoples have the right to self-determination, and all peoples have the right to freely pursue their economic, social, and cultural development. These principles are to serve as a safeguard where Indigenous rights can't be affected or impacted or diminished without this consultation and free, prior, and informed consent. The central element of FPIC is inclusion and disclosure and respect for Indigenous peoples' decision-making processes. The UN Declaration requires that the free, prior, and informed consent of Indigenous peoples be obtained, especially in matters of fundamental importance for our rights, our survival, our dignity, and well-being. Article 19 provides that states shall consult and cooperate in good faith with Indigenous peoples, concerned through their own representative institutions in order to obtain their free, prior, and informed consent before adopting or implementing legislative or administrative measures that may affect them. Canada's UNDRIP is a matter of fundamental importance for Indigenous peoples, but unfortunately, the principles of FPIC were ignored during the C-15 engagement process. And as a result, the imposition of Crown sovereignty over Indigenous peoples continues, and it disregards and undermines our own laws. There's little evidence, as both Grand Chief Abram and Sara raised, that The legislation will ensure that UNDRIP at the international level will have an equal value at the domestic level, nor that the tools will force the government to improve over time. The language used in the Act allows Canada significant discretion on the implementation process. And as noted, the process of domesticating UNDRIP will be undertaken almost entirely by Canada and will be subject to the constraints of Section 35 jurisprudence. The Sparrow test will continue to apply in instances related to Section 35 rights, and UNDRIP articles could be easily overridden in the name of national interest. Given the weak language of the Act, Canada can interpret the spirit and intent of the declaration as they see fit. And this includes FEPIC, which will likely follow the previously established standard of aiming to secure consent, which amounts to no more than consultation. There are too many unanswered questions left hanging in the balance in order to be able to make an informed decision. We cannot support legislation that is okay for now or something we can live with or just wait to see what happens. This legislation is of fundamental importance, and as nations and rights holders who will be affected by C-15, we deserve better. Yeah.
Thank you very much for your remarks. And we are now going to open it to discussion. And I'm very much looking forward to hearing more about all of the points that were mentioned. Just starting with really underlining this point, Deputy Grand Chief Loft, this point about the free, prior, and informed consent, and then about the involvement. So you're saying that to this point, there has been none of that with respect to Bill C-15, with respect to the association and the government.
It's been very limited consultation. And as I mentioned, as far as my understanding, the window of time was quite short in order to be able to engage. And many people were left out of that process. And I think it's troubling when rights holders come to you, so such as AIAI, come and present an invitation or request an invitation to the minister to speak about C-15. And when that goes ignored, that doesn't speak to these principles that are supposed to be undertaken by UNDRIP. So I think that that should give everyone some concern over how this process has developed, how folks have not been engaged, how it just seems to have been pushed through. It's definitely part of an agenda to get things done and get things done quickly. And like I said, I think most people, as far from the conversations that I've had, are supportive of UNDRIP. And I think in many ways, we've been backed into a corner to be able to accept something because it's there. And that's not a way for us to be able to make decisions about our rights. It should be based on inclusion. It should be based on disclosure. And I feel that there are many pieces that are missing from these processes.
And maybe just to pick up on that point, what does nation to nation engagement look like? And with respect to Bill C-15, or more generally, and I'll just throw this out to all of you, what should that look like? What are the essential elements? Why isn't it enough to say, well, we've consulted with some Indigenous peoples, or we've consulted with this particular association? If you can just help explain that a bit, I think that sometimes folks are a bit confused about that. Who would like to take a crack at that one? Yes?
Maybe I'll go first.
Okay.
I think firstly, it should be recognized that, a few years ago, the federal government signed an agreement with the Assembly of First Nations, which would basically said that the federal government should try to do nation-to-nation relationship with, with the nations themselves, and that the AFN itself is not a national government. It's merely a body that's supposed to, it's not a representative body, nor is it a rights holder. And the rights holders are actually the people themselves. And so right off the bat, that's where they kind of missed is, because the AFN appears to be in favor of it, they've taken that as to mean that most Indigenous peoples are in fact in favor of the bill, but they don't know that. If they went and actually talked with the First Nations themselves and their stakeholders and their members, who are the actual rights holders, to understand what the impacts of any kind of Bill C-15 going forward and UNDRIP could be. It's not that we're, particularly against UNDRIP itself, but how it's applied can have a great impact on how your rights are construed, both through, the federal legislative lens and the legal lens as well. So, just because there's national leaders that's lined up behind it, that doesn't mean a lot in terms of, what Stacia talked about was the lack of overall consultation with the actual rights holders that hold these rights and how they would be impacted by that. So right off the bat, they didn't do that due diligence of actually going out, because this is such a big, huge thing, UNDRIP, and really there should be a more exhaustive process when you're talking about this and how you're going to move forward. If you really want to decolonize, then you have to have these kind of things in mind and, face the truth that the that the doctrine of discovery holds great sway over the current legal and legislative framework of how Canada relates to its First Nations peoples, and how are you going to dismantle it if you're going to domesticate under current Canadian laws. So, that just needs to be a different approach in terms of how that piece was done. So, yeah, thank you.
Mm-hmm. Mm-hmm. Did anyone else want to add anything about that particular question? No. Okay. Sarah, coming back to you, because I know that you've looked into the guts, and just to give you a bit more of an opportunity, did you want to elaborate on any more of the points you're making about this particular piece of legislation?
Yeah, I think that one of the key takeaways that Indigenous people should know about the declaration is that it does uphold binding international legal principles, including the right to self-determination. And frankly, I think that's a real problem for Canada because of their existing so-called inherent rights policy, which actually denies freestanding inherent rights, and actually as part of the policy asks you to draw down powers from either a provincial or federal government. So it's really a contingent rights basis, and denies that international binding legal principle of recognizing the right to self-determination of Indigenous peoples. The decision-making, the rights to participate in decision-making around projects or developments that impact directly on Section 35, constitutionally protected rights, is also a problem again and again. The question of whether or not Canada is actually upholding that international standard of free, prior, and informed consent is a continued discourse between Canada as a member of the United Nations. And so these are things that are already happening, and the principle of conformity to international law is something that Canadian courts do, especially around the Charter and international human rights standards. So do we need the bill? We do. I think a bill would be helpful, but this bill in its current form is actually detrimental to what the Declaration is already capable of doing in Canadian common law.
Thank you. And we've heard from some other First Nations that also have said that they haven't had a chance to be involved, to be engaged with on a nation-to-nation basis. Are you in touch with other First Nations outside of the association with respect to Bill C-15?
If that's specifically to me,
it was general, okay. But you can certainly answer any of these questions. Anyone can. So please go ahead.
Yeah, I think that there is actually a bit of, and again, AIAI is being a leader on this front, has been speaking to other organizations. So I'd let Grand Chief speak to that. But specifically in the legal community, there's definitely discourse going around about whether or not the bill does do enough to try to support it, and whether or not we can make enough revisions to it that we could actually get more support from Indigenous peoples. But for now, there seems to be an outcry of non-support within the Indigenous community.
Well, certainly within Ontario region, we declined to participate in an engagement process because we felt it was deficient from the start in the manner in which they were going at and the timeframes. There's also groups across the country, for instance, Onion Lake is a First Nation out on the border of, I think, Saskatchewan and Alberta that is also vehemently opposed. And they're also part of a larger treaty group, which also, I believe is also opposed to the bill as it stands right now as well. And a lot of this stems from their engagement process, of doing that properly. And also the way that the bill is framed legally. It has a lot of flowery language in a preamble, but unfortunately that's not legally binding. So we have to look at the definitive sections within an UNDRIP that actually will have legal standing and implications going forward. And so based on that, there are, more than just us. There's Ontario region as a whole, and also there's a few more out west as well. So, we just want to make sure if it's going to be done, let's restart this from the beginning and let's do it right if we're going to implement Bill C-15.
Mm-hmm. Deputy Grand Chief Loft, did you want to add something?
I actually, with Joel's comments just around Ontario's opposition, I mean, that's what I'm aware of, as well as Onion Lake. I know there are a few other nations within other provinces as well that that are opposed, that I've seen either social media posts on. I think it comes down to the kind of relationship that each nation has in this country. So depending on what sort of treaty they come from or non-treaty area, I think really determines how nations have approached this this legislation. So I mean, there hasn't really been, I think, a space or a forum, and I think today is maybe one of the very few times that so I don't want to call us small, but I mean, a relatively, solid group of nations, or 7 nations or member nations, have been able to come together to be able to speak on this. There hasn't been the space afforded for it. And like I said earlier, despite efforts to try to reach out to create space, those requests have been ignored. So I think as more opportunities present themselves for nations and rights holders to be able to speak on this, I don't think that we're an anomaly. I don't think that our points or our viewpoints or our position on this is unique in any way. I think that there are many who just haven't had that opportunity.
Mm-hmm. So just, I guess, looking forward, and Grand Chief Abram, I take what you said, and just picking up from that, where you said, let's do it right. I know that this is a big question, and so only answer the parts that you feel you can, or maybe you've thought it all through. If we're doing it right, what would doing it right look like to you? And again, once you've answered, I throw it out to the others here as well. What would doing it right look like if we're going to start from scratch and do it right?
Well, I think it means, doing that nation-to-nation relationship, consulting with each and every First Nation individually, not with groups, because they wanted to consult with AIAI, they wanted to consult with Chiefs of Ontario, they wanted to consult with AFN, but none of these organizations are the actual rights holders. The people within these individual nations are the rights holders, and that's where you have to start. At the end of the day, I think you're going to have to look at opening up the Constitution People don't know this, but back in 1982, when they put Section 35 in the Constitution, there are supposed to be 3 constitutional conferences to define the meaning within Section 35. And Section 35 says it hereby affirms the Treaty on Aboriginal Rights of Aboriginal people in Canada. And so they wanted to know what exactly does that term mean. And so they're supposed to have 3 constitutional conferences. They had 2. Our First Nation view on that was that it was a full box of rights. And the government's view that it was an empty box of rights to be argued and added, through court processes. Unfortunately, Canada abandoned those talks after 2 meetings. And so that meeting was never really sufficiently defined. It's only been defined through, Supreme Court decisions. And again, they are looking at it through a colonial viewpoint, using the doctrine of discovery, which, as most people know, is a racist document, and it's a racist, it basically it upholds white supremacy at the time, is what it did. And, it led to slavery, it led to dispossession of land, it led to a whole bunch of things throughout the world, when colonialism was at its height. And unfortunately, a lot of the power structures are still based on that. And so, if we're going, and if, UNDRIP probably wouldn't exist if there wasn't colonialism. And so part of what its reason is raison d'etre is to, in fact, to decolonize. And Canada, if they have to decolonize, it's facing the truth about the past, and it's being willing to change for the future, for the benefit of everyone. And the Indigenous peoples who originally are here, they're still here. There have been a lot of attempts to eradicate us through residential school, through different things throughout the years. But we're here, and we think we just deserve that fair shake. And if UNDRIP can help do that, then that's great. But that's going to mean looking at the things and laws and legal that still rely upon a doctrine as their basis going forward, and being willing to change those. So I think maybe that's my commentary on that. Thank you.
Thank you very much. Was there anyone else who wanted to add to that specific question? Deputy Grand Chief or Sarah?
Sure,
yes,
yeah, just
go ahead.
Yeah, I think my opening comments were, starting off in a good way, right? You start off a process in a good way, and this kind of I would say endeavor is going to take time. It's going to take time. It's going to take some effort, some planning, some thoughtfulness in order for the process to be meaningful. So, I know that time is not always on everyone's side, but it's so important, particularly when you have a piece of legislation that is going to impact Indigenous peoples, that it starts off in a good way at the very beginning. So yeah, it would probably take some investment of dollars and coordination to be able to reach out to those rights holders, to be able to have discussion on this. So it could take a year, it could take 2 years. And this is what I was saying earlier. Well, when your back is up against the wall and, the carrot is being dangled, and say, well, this is good. It's something. And like I said, sure, it's something, but is this the best that we can have? No, it's not. And should we accept that because that's what's there in front of us? No, I think it's important that we establish what a nation to nation relationship is. And that is so critical, and I think about how history has played out, how decisions have been made, and they come back to haunt us, these decisions, when we don't start in a good way. And so I think there's an opportunity here. I think there's a real opportunity to press pause, take a moment, and think about how and what the approach could look like, and engage those who can actually lend some expertise and in order to shape this process. So, as much as maybe many will see this as perhaps being a lost cause. There's nothing we can do. There's always something that can be done. And there's nothing wrong with admitting and saying, you know what, we didn't do this right. We need to go back to the drawing board. And this is the way we're going to do this. So I think, like you had mentioned, it's kind of a big question, but it doesn't mean that something can't happen.
If I can add one more
Yes,
thing,
please, yes.
Even UNDRIP itself isn't a perfect, declaration. There was several different iterations of it, and the third one was the one where they added Article 46, which Stacia was talking about earlier. And so even implementing that, could be harmful to First Nations as well. So I think really what we're talking about is a bigger discussion. It's not just about UNDRIP, but it's about Canada's relationship to Indigenous peoples and at its root, and how do we proceed in a good way to decolonize that relationship. There's an old treaty, the first treaty that was signed between Europeans and First Nations people was the Turo Wampum, or the Gaswanta, what we call it. And it's a white, basically a white wampum with 2 rows of purple going across it. And it's supposed to signify, and it was made with a Dutch and an Iroquois back in the day. And it's supposed to signify our 2 peoples and crafts going down a river of life, each containing their laws, customs, traditions. And there was 3 white lines between them, which was peace, respect, and friendship, which meant that no craft was supposed to guide the other one. But unfortunately, that's not the way that things have been working, because I don't think we, as Indigenous peoples, we weren't aware, of the doctrine of discovery back then, and that's what would overtake the whole relationship after a period of time. So I think it's kind of rewinding that back to the original understanding of that relationship, and going back to that, because even implementing UNDRIP in its entirety, especially, it's going to be very harmful for First Nations, especially considering Article 46, which is not ideal, and that was added in without the consent of Indigenous peoples before it went to the UN floor for voting. So, even UNDRIP in itself isn't perfect. It has some good things in it, but I think that should be mentioned here as well.
Thank you very, very much. I'm going to just give you all the opportunity before we go to the closing prayer, just to, again, tell I guess first the parties, those who aren't in government, like ourselves, people who want to be good allies to you and to the nations that you represent, what we should do now. As you said, this is a bill that is headed toward second reading. We, as you said, we are where we are in this process. There's not much time. It's very time sensitive. What can be done in terms of those who would seek to be good allies, and then also apart from the opposition parties, those outside of politics altogether who want to be of use. What is the ultimate message then to the government that you would like to send? And I'm just going to invite each of you to respond to those 2 things, and then we'll go to the closing prayer. There's no particular order. I don't know if Chief Carr is still with us, or would like to go first. Yes, Chief Carr.
I am. I just with the computer and the network in the country, it goes off and on. So there's lots that can be done, and it's, I guess, first starting with learning why UNDRIP isn't favorable to this legislation, I should say, as it's written, isn't favorable to First Nations, and understanding that, and hearing, it's social media is such a big place. And I actually saw on social media a while ago where the UNDRIP legislation was being promoted. And so when people and young people pick that up, and then they think it's good, but it's really important that everyone, our grassroots people, everyone besides the politicians understand why this is not beneficial. We always talk about our 7 generations to come and how important that is. And the work that we do is guided by our ancestors for those next generations. And when we look at these pieces and see how the colonization process has happened, we really need to understand all that. And that's a lot of work, and it takes a lot of time. But first, I would say that is try to get an understanding. And, you know, we have work out there. We've put AIAI has put out briefing notes. We have put out information. And then the second part is to support us through the legislation piece, you know, write to your MPP or MP. Support us with that way. I don't want to say come out and do, you know, walk with us, because we're in a time of pandemic. But showing those ways that you support us, use your social media, use your letter writing, anything that can help with that understanding, and then contact us, ask us how, you know, what you need to know or how it can be supported that way, and what we can do to help you support us. And I've had that. I had put something on my social media in regards to UNDRIP, and immediately one of our citizens had asked, how can we help? So, you know, there's those pieces there that we can support through AI and creating, you know, that information to get it out. So Miigwech, thank you. And thank you for this opportunity.
Thank you for being here. I'm just going to again, just go through, feel free to, I would really love to hear from all of you on this one. So Sarah, did you want to share some thoughts?
Yeah, I think one of the things that Canada is also doing as a government is also explaining to industry and other stakeholders how the bill C-15 is not going to change anything. They've made statements, for example, a quote, "If passed, this legislation would not change Canada's existing duty to consult Indigenous groups or other consultation and participation requirements set out in other legislation." So those kinds of comments, I think, are really detrimental to the so-called most important relationship with Indigenous peoples. And I think generally the public needs to know that this government has actually been all words and no action on reconciliation so far. There's some great reports about the lack of implementation of the very, very key and important calls to action, including as a lawyer, and trying to get my mind around this. How do we strip away the doctrine of discovery in terra nullius from Canadian property law, Canadian law related to Aboriginal title, and the recognition of Aboriginal title as an Indigenous form of property right? It's a really difficult discussion, but so long overdue. And I think that this government frankly does respond to public outcry, and that's what we need on this. You know, finally some real action towards true nation-to-nation reconciliation.
Thank you very much. Grand Chief Abram? Or no, I see. Yes, go ahead, please.
Yes, I'll let Grand Chief have the final words before we close. Both Chief Carr and Sarah make some great points about what not only individuals can do, but also too what these institutions can do, or at least think about how they are promoting, how they are promoting colonization. And you know, I think, you know, writing to your MP is definitely a good step. Following the legislative process, finding the ways in which that perhaps you know, may be able to be involved in the committee process, making people who have space, who have forums that are available, making an effort to include individuals with expertise to have conversations like this. I think that's very important. I think, with Sarah's comments on property law and how we really need to dismantle these concepts. It's so important, and it's embedded in every system that we have. And I think for individuals to not only inform themselves, and as Chief Carr mentioned, reach out, have conversations with people who have that knowledge, I think is so important. And so many times, and as we have seen over these many years, hundreds and hundreds of years, is that opinions are formed and decisions are made on our behalf all of the time. And that needs to stop. We have knowledge, we have expertise, we are able to come to the table to have a discussion about not only the impacts, but also solutions. How can this be better? How can this, or these processes or legislation or practices, how can they be best informed by Indigenous peoples? Because ultimately it's us who are affected by these processes. So I'll hand it over to Grand Chief.
Thank you. We had some great comments, on what people can do, but I also have comments on what MPs can do. So I really like to thank the Green Party for the only party that was willing to kind of work with us on this. And so I would ask MPs to vote to their conscience. When you're voting for Bill C-15, in reality, you're voting for continuation of white supremacy over Indigenous peoples. So it's a vote of conscience in many ways. They have to educate themselves about the true history of Canada, about the colonization, about, how according to the doctrine of discovering terra nullius, Indigenous peoples weren't even considered human beings. And that's why they were able to lay claim to the land. And that's what's led to a lot of the negative things that's happened in Indigenous peoples over the years, whether it's residential school or 60 scoop, anything like land dispossession. It's all been based on that one thing. What Sarah talked about was doctrine of discovering terra nullius. How do we remove that? And so, I think this is a bigger discussion that is long overdue. So I think it's a vote of conscience for many MPPs. Are you continue to willing to hold up a system that enforces, that supremacy over Indigenous peoples, or are you willing to stand up for what's right? And let's turn that conversation around. Let's really talk about how we decolonize this country.
Thank you very much for that. And before I hand it over to Elder Bell for the closing prayer, I just want to say thank you very, very much for being here. Thank you for reaching out to us in the first place and telling us what we could do to help. And it's our pleasure to provide this our platform for your voices, and I certainly hope that it will encourage others to do the same. And as you said, we all of us have a role to play in this. Just to say very clearly again that we believe in true nation-to-nation engagement. I don't know how to put this plainly for people to understand. I worked for a while as a diplomat overseas, both for our government and in multilateral institutions. And you don't go to France to find out what Greece thinks. That it's just that simple, and there's no difference. And it sometimes seems hard for that to be understood in the context here. But that's basically it. Every nation has the right to decide who will speak on their behalf, and there is no substitute for that. And so I'm very pleased to have been able to, on behalf of our party, have offered that opportunity. And we certainly are here to do all we can. I'm just looking at the directions from the team. We're going to have a media availability, but I believe that we are going to have that after we sign off from Facebook. Is that correct?
Yes, that's correct.
Okay. So can we have the closing prayer for this before we sign off, and then we'll have the media availability directly afterward. Miigwech, and thank you so much. I'm going to pass it now to Harvey Bell, our elder, for the closing prayer.
We're good?
Yes, perfect.
Oh, bonjour. So we give thanks again to Gitche Manado for guiding us this morning's meeting. And we also ask for continue to protect our citizens, no matter where they are in Indian land from this COVID. And I want to put one more little thought in there as well. Happy birthday to Sara. Aha, Chimibet.
Happy birthday. Happy birthday. It was my mom's birthday this weekend, and I dragged my son up in a press conference just a couple of weeks ago for his birthday. So a lot of high profile birthdays happening this month. Happy birthday. And you know, I hope this is a fitting way to celebrate your birthday, at least a part of it. Okay, so with that, we're going to say miigwech and sign off of Facebook. Merci à tout le monde d'être ici avec nous aujourd'hui pour cette discussion énormément importante. Si vous voulez prendre contact avec l'association, vous pouvez le faire à travers du Parti vert, et nous allons mettre les vidéos dans nos réseaux sociaux aussi. We'll put the videos up in our social media. We'll make sure that those who want to be in direct contact with AIAI have the opportunity to do that. Miigwech to everyone for joining us today, and could continue to follow this as we will. Thank you so much.